I'm going to talk about the Code for Crown Prosecutors. Now, the legislation for this is set out in Section 10 of the Criminal Offences Act 1985. That legislation sets out the position for the Director of Public Prosecutions to set out a code for Crown prosecutors to follow. We're currently on the 7th edition of the code, published in January 2013. As a matter of interest, the Director for Public Prosecutions is considering researching at the moment an updated version of the code. But for the purpose of this video, I'm talking about version 7, published January 2013. It's the Code for Crown Prosecutors, so it incorporates, as well as the Crown Prosecution Service, organisations such as the Military's Service Prosecuting Authority. The Code for Crown Prosecutors sets out what a prosecutor should consider when deciding whether or not to go forwards with a prosecution. It's important to note that this is an ongoing code. That means that the code applies when the decision is first considered whether or not to prosecute, and then if the decision has been taken to prosecute, it applies on an ongoing basis throughout the lifetime of the case. This means that it needs to be considered whilst the matter is being prepared for trial and whilst the matter is at trial. The Code of Crown Prosecutors is most easily split into two parts: the Evidential Test and the Public Interest Test. These are two distinct parts of the code, but what is important to note is that if the Evidential Test is not passed, then the Public Interest Test is not even considered. Therefore, a prosecutor must be convinced that the Evidential Test is satisfied, is met, before going on to the Public Interest Test. The Evidential Test itself can be split into three parts. The first is whether the evidence at court is admissible. If the evidence at court is admissible, then the prosecutor will need to consider whether the evidence is reliable, and if the evidence is reliable, whether or not it is credible. So to give an example, when considering whether or not the evidence is admissible in court, might be a situation where a suspect has been interviewed by the police and may, for example, have given admissions to the police. However, if the suspect was not correctly cautioned prior to giving those admissions, then it might be that the evidence obtained from the interview might not be admissible in court. It might, for example, have been the subject of a Section 74 application under PACE. It might have been that the defence were able to argue that the evidence was not admissible in court. Therefore, the prosecutor needs to consider the prosecution case to decide whether any of the evidence is admissible. Now, assuming that the answer to all that is yes, then the further tests are whether the evidence is reliable and whether the evidence is credible. Remember also that the test for the Code for Crown Prosecutors is whether there is a realistic prospect of conviction. So applying whether the evidence is admissible, whether it is reliable, and whether it is credible, prosecutor needs to consider whether or not, having taken those three matters into account, whether or not there is a realistic prospect of conviction. Now, if the prosecutor concludes that there is a realistic prospect of conviction, and the prosecutor goes on to the next stage of the Code for Crown Prosecutors, which is the public interest test. If, however, the prosecutor concludes that there is not a realistic prospect of conviction, then that stage should be the end of the process and the prosecution should not proceed. In my opinion, speaking personally, it appears that the Code for Crown Prosecutors Evidential Test, whether there is a realistic prospect of conviction, is very similar to the half-time submission rule, R.B. Galbraith, the Crown against Galbraith, which is the test applied if there is a half-time submission at trial following the prosecution evidence, whether there is a realistic prospect of that a jury properly directed by a judge could conclude that there was a realistic prospect of conviction. It appears to me that the Code for Crown Prosecutors Evidential Test is very similar in tone to the Crown against Galbraith half-time submissions test. So, assuming therefore that the Code for Crown Prosecutors Evidential Test is met, we move on then to the public interest test. The public interest test, as the name suggests, is for a prosecutor to consider whether, having applied the evidential test, it is in the public interest to justify a prosecution. There could be a whole range of reasons why a case, although there is sufficient evidence to justify prosecution, may not be in the public interest to proceed. For example, it may be a very minor offence committed by somebody of previous good character. It may be that the resources required from the police and the Crown Prosecution Service to bring a case do not justify the case being brought. It may be that so many resources are needed with witnesses or evidence or whatever that it isn't justified, the expense doesn't justify the prosecution. It may be that the age of the suspect at the time when the offence was allegedly committed is relevant. If the suspect was a child at the time, if they were under 18 at the time, that might be a reason for a prosecutor to consider that the public interest test is not met. The prosecutor might want to consider the wider impact on the community. So, for example, if a particular low-level offence is prevalent in the community, that might justify the public interest test being applied. Equally, if there are wider implications, obviously each case would have to depend on its set of facts, the prosecutor might conclude that it wasn't in the public interest to proceed with that particular offence. There will be cases where, even though the evidential test is met, for whatever reason the police do not wish to proceed in order to protect their sources. Those cases may perhaps be quite rare to come into the court system, but the prosecutor will want to consider whether it's justified in bringing a prosecution for a relatively low-level offence if it means that a police source is going to be exposed. So, to recap, the Code for Crown Prosecutors applies to all prosecution services, both the CPS and others. Its legislative basis comes from Section 10 of the Prosecution of Offences Act 1985, and it's published by the Director for Public Prosecutions. The test is in two stages, the evidential test and the public interest test. The evidential test is divided into three. Is the evidence admissible? Is it credible? Is it reliable? And applying those three together, is there a realistic prospect of conviction? If the answer to that is no, then the public interest test isn't even considered. If the answer is yes, then the public interest test is considered, and there will be a wide range of reasons why, even though a case might be justified on the evidential test, it doesn't meet the public interest test. And finally, that the Code for Crown Prosecutors is an ongoing code. It applies at the time that the decision is made to bring charges to prosecute, and it applies throughout the life of the case and at trial.